If you are a business owner who have entered into a contract with another company, this information is crucial for you to understand. Firstly, let's define what we mean by breach of contract. A breach of contract occurs when one party fails to fulfill their obligations as outlined in a legally binding agreement. This can include failing to pay for goods or services, not delivering on promised work, or violating terms and conditions. So what is the statute of limitations for breach of contract in Florida? In general, the statute of limitations for breach of a written contract in Florida is 5 years. This means that a lawsuit for breach of contract must be filed within 5 years from the date of the breach. However, there are some exceptions to this rule. For contracts involving real estate, the statute of limitations is shortened to 4 years. And in cases where a written contract specifies a different time period, that time period will apply instead. It's important to note that the statute of limitations clock starts ticking from the date of the breach, not the date the contract was signed. This is why it's crucial to take action as soon as possible if you believe a breach of contract has occurred. Now, what happens if you miss the statute of limitations deadline? In most cases, your lawsuit's going to be dismissed and you'll lose the opportunity to seek legal action for the breach of contract. This is why it's important to consult with a lawyer and file a lawsuit within the appropriate time frame. However, there are some defenses that may be used to extend the statute of limitations or excuse a missed deadline. These include fraud, concealment, incapacity, or duress. If any of these apply to your case, it's best to consult the lawyer to see if you have a valid defense. In conclusion, the statute of limitations for breach of contract in Florida is an important aspect to consider when entering into any agreement.